So, very good evening, all the participants. Today, I have tried to link some of the provisions relating to bankruptcy. Although I had already given the rules or regulation number, but I have provided some cross linking also. And similarly, I link this insolvency provisions also, so that those who are reading online, so they are able to just go to that particular rule or regulation. Okay. So I can share my PPT with you. I hope now it is visible. Right? So now this bankruptcy. In bankruptcy, we had seen some of the provisions, but now let us see the provisions relating to distribution of the estate of the bankrupt. Chapter 5. So what chapter 5 says? (492). Slide number 492. So these sections I think we have already seen, and now we can directly move to. So as you can see, I have linked the relevant rules and regulations, है ना? अब जैसे ही उस पर क्लिक करेंगे तो that rule or regulation will open. Now let us go directly to chapter 5. Chapter 5 talks of the administration and distribution of the estate of the bankrupt, because that is the most important activity, and that is why it has been kept separately in a separate chapter. So this starts with section 149. So what section 149 says? Section 149 talks of the functions of the bankruptcy trustee. 149. Okay. So now we have to compare how this section is different from the functions of the liquidator. So if we see the functions and if we make a cross comparison between the functions of the liquidator and functions of the bankruptcy trustee, they look more or less the same. Because liquidator also has to say in his preliminary report whether he wants to investigate the affairs of the bankrupt. So the functions of the bankruptcy trustee are to investigate the affairs of the bankrupt, realize the estate of the bankrupt, and distribute the estate of the bankrupt. Can anybody tell me the related section in liquidation? Liquidation, what is the related section which talks of functions of the liquidators? Is there any such section? Section 35 you can see.
Yes, sir.
Powers and
Powers and duties of liquidator.
liquidator. So section 35 if we see, so that talks of claims and all those things. Custody and control. So section 35, if we read, we can make a comparison between section 35 and section 149 and 150. Section 149 talks of functions of the bankruptcy trustee, and section 150 talks of the duties of the bankrupt towards the bankruptcy trustee. Now, what are the duties of the bankrupt towards the bankruptcy trustee? The bankrupt shall assist the bankruptcy trustee in carrying out his functions under this chapter by giving to the bankruptcy trustee the information of his affairs, attending on the bankruptcy trustee at such times as may be required, giving notice to the bankruptcy trustee of any of the following events which have occurred after the bankruptcy commencement date. Now here there is one important question, whether during bankruptcy trustee the custody and control comes with the bankruptcy trustee or it remains with the bankrupt. This is the question.
Trustee, sir.
Okay, any section to support this? The section you can find when the word bankruptcy estate is defined. Now we have to see where the bankruptcy estate has been defined. Is it given in section 79?
No, sir.
It is not there in section
79.
79. Okay. Now let us see some other section on this.
I think 154, vesting of estate of bankrupt in bankruptcy trustee.
Right. Section 154.
4.
Okay. So section 154 talks of the vesting of the estate of the bankrupt in bankruptcy trustee. So it says the estate of the bankrupt shall vest in the bankruptcy trustee immediately from the date of his appointment, and vesting shall take place without any conveyance, assignment or transfer. Okay. So very good. Thank you. 154. So section 149 and section 150, we have to make a corresponding comparison with section 35, which is during liquidation. So these are all general things you can go through, nothing much. Attending on the bankruptcy trustee, giving notice to the bankruptcy trustee of any of the following events which have occurred after the bankruptcy commencement date. So there could be a situation where the bankrupt acquires any property after the bankruptcy commencement date, or there is any devolution of any property. What is the difference between acquisition and devolution? Acquisition means by conscious effort, say purchase. Devolution means by succession, something which he gets by involuntary effort. Devolution, increase in the income of the bankrupt and doing all other things as may be prescribed. The bankrupt shall give notice of the increase in income or acquisition or devolution of property under clause C of subsection 1 within how many days of increase? Within 7 days of such increase, acquisition or devolution. Whether there is any format for notice, any format for notice, for giving this notice, there is no such format. And the bankrupt shall continue to discharge the duties under subsection 1 other than the duties under clause C even after the discharge order under section 138. So it says, other than the duties under clause C. What are the duties under clause C? The duties under clause C are to give notice of acquisition, devolution, increase, etc. So this portion he need not after the discharge order. But other than this, other than the duties under clause C, which talks of acquisition, devolution or increase, he has to give other information. Okay. 151. What are the rights of the bankruptcy trustee? So these rights, now if we compare them with the rights of the liquidator, rights of the bankruptcy trustee. So any corresponding section for rights of the liquidator?
Powers, state.
It is given in section 35 itself. So
Powers
section 35
liquidator
itself says draw, accept, etc. So it says 135, 1G, H, etc. So this is something similar to that, similar to liquidation provisions. What it says, he can hold property of every description, he can make contracts, he can sue and be sued, enter into engagements in respect of the estate, employ persons to assist him. Okay? execute any power of attorney, deed or other instrument, and do any other act which is necessary or expedient for the purpose of or in connection with the exercise of his rights. So all these are the rights, because the estate of the bankrupt vests in the bankruptcy trustee. So he will do all these things. Suppose some property document has to be signed, so he will sign instead of the bankrupt. 152. General powers of the bankruptcy trustee. The bankruptcy trustee may, while discharging his functions under this chapter, sell any part of the estate of the bankrupt, give receipts for any money received by him, prove rank, claim, and draw a dividend in respect of such debts due to the bankrupt as are comprised in his estate, where any property comprised in the estate of the bankrupt is held by any person by way of pledge or hypothecation, exercise the
क्या
right
कहाँ
of
गए
redemption.
नहीं रख लो ना
वो
हम ही रख लो
एसपी सिंह साहब म्यूट कर लीजिए अपने को. So wherein property comprised in the estate of the bankrupt is held by any person by way of pledge or hypothecation, exercise the right of redemption in respect of any such property subject to the relevant contract by giving notice to the said person. ठीक है. Where any part of the estate of the bankrupt consists of securities in a company or any other property which is transferable in the books of a person, exercise the right to transfer the property to the same extent as the bankrupt might have exercised. So, whatever are the powers of the bankrupt, they will come to the bankruptcy trustee. Deal with any property comprised in the estate of the bankrupt to which the bankrupt is beneficially entitled in the same manner as he might have dealt with it. So, we have seen that there are three sections. 150, 151, 152. So all these sections, for all these three sections, there is only one section in liquidation, section 35. Something similar. 130, 153, approval of creditors for certain acts. The bankruptcy trustee, for the purposes of this chapter, may, after procuring the approval of the committee of creditors, carry on any business of the bankrupt as far as may be necessary for winding it up beneficially. Okay. So now the thing is that he is carrying on the business for winding it up beneficially. He is not keeping it as a going concern. So if they ask you a question whether during bankruptcy it can be sold as a going concern, the idea is to wind it up beneficially. Okay. As in case of voluntary liquidation. In case of liquidation, the going concern concept will prevail, but here he will carry on the business as far as may be necessary for winding it up beneficially. Pradeep ji, any section to support going concern concept during bankruptcy? So you can just explore and write in the group if there is anything. But here, if we read this section, it says the purpose is to wind up the business. Bring, institute or defend any legal action or proceeding relating to the property comprised in the estate of the bankrupt, except as consideration for the sale of any property, a sum of money due at a future time, subject to certain stipulations such as security. So here they say all these things can be done only after procuring the approval of the COC. So this is something similar which can be equated to section 28. In section 28 during CIRP, there are certain actions which cannot be taken without the prior approval of COC. But here the word prior is missing. You can say what it says, after procuring the approval. So the word prior is missing here. You can just note it down. Mortgage or pledge any property for the purpose of raising money for the payment of the debts of the bankrupt, where any right, option or other power forms part of the estate of the bankrupt, make payments or incur liabilities with a view to obtaining for the benefit of the creditors any property which is the subject of such right, option or power. Refer to arbitration or compromise on such terms as may be agreed any debts subsisting or supposed to subsist between the bankrupt and any person who may have incurred any liability to the bankrupt. Make compromise or other arrangement as may be considered expedient. Make compromise or other arrangement as he may deem expedient with respect to any claim arising out of or incidental to the bankrupt's estate. So all these things, basically, these are some major acts. These may arrange for arbitration, compromise, then mortgage, accepting as consideration for sale, etc. So all these things, for this approval of the committee of creditors is required. Appoint the bankrupt to supervise. So this point we have already seen.
877
एक
911
ये ना आपको आईफोन कहीं से कुछ वो आ रहा है, आप म्यूट कर लीजिए अपने को प्लीज. Appoint the bankrupt to supervise the management of the estate of the bankrupt or any part of it. So, as we have seen that one of the partners, he was appointed to supervise the management of the cinema hall in that case study. So, he can appoint the bankrupt also. Carry on his business for the benefit of his creditors. Assist the bankruptcy trustee in administering the estate of the bankrupt. Okay. The word is appoint. So, if the word appoint is there, that means he may be entitled for some remuneration also. Chali. 154 talks of vesting of the estate of the bankrupt in the bankruptcy trustee. The estate of the bankrupt shall vest in the bankruptcy trustee immediately from the date of his appointment. Okay. And the vesting shall take place without any conveyance, assignment or 155. Estate of the bankrupt. The estate of the bankrupt shall include all property belonging to or vested in the bankrupt at the bankruptcy commencement date. Okay. The capacity to exercise and to initiate proceedings for exercising all such powers in or over or in respect of property as might have been exercised by the bankrupt for his own benefit at the bankruptcy commencement date or before the date of the discharge order passed under section 138, and all property which by virtue of any of the provisions of this chapter is comprised in the estate. Okay. Estate of the bankrupt shall not include what? So this section 155 is similar to section 36 in liquidation, which talks of liquidation estate. Okay, no? There also there are certain exclusions. So here the estate of the bankrupt shall not include excluded assets. Excluded assets we have already seen, provided they are unencumbered. So tools, books, vehicles, equipments, etc. Ornaments, LIC. We have all seen the definition of excluded assets in section 79. So estate of the bankrupt shall not include this because we are dealing with humans here. So property held by the bankrupt on trust for any other person. All sums due to any workman or employee from the provident fund, pension fund and gratuity fund and such assets as may be notified. 156. Delivery of property and documents to bankruptcy trustee. The bankrupt, his banker or agent. This very important section 156. So this is something similar to custody and control. Here he is delivering the property and documents. The bankrupt, his banker or agent or any other person having possession of any property, books, papers or other records which bankruptcy trustee is required to take possession for the purpose of the bankruptcy process shall deliver the said property and documents to the bankruptcy trustee. The definition of property we have already seen in section 3, subsection 27, I think. 157. 157 talks of acquisition of control by the bankruptcy trustee. The bankruptcy trustee shall take possession and control of all property, books, papers and other records. So something similar to custody and control relating to the estate of the bankrupt or affairs of the bankrupt which belong to him or in his possession or under his control. Okay. Where any part of the estate of the bankrupt consists of things in actionable claims, they shall be deemed to have been assigned to the bankruptcy trustee. Okay. Without any notice of the assignment. 158, very important section. 158 to 164. 158 talks of restrictions on disposition of property. Any disposition of property made by the debtor during the period between the date of filing of the application for bankruptcy and the bankruptcy commencement date shall be void. So suppose a petition for bankruptcy has been filed and before it is admitted, if there is any disposition of property which is made by the debtor, so it shall be void. Any disposition of property made under subsection 1 shall not give rise to any right against any person in respect of such property, even if he has received such property before the bankruptcy commencement date. So even the plea of good faith for value and without notice of the filing of the application for bankruptcy will not work here. So this transaction will be considered as void. For the purposes of this section, the term property means all the property of the debtor, whether or not it is comprised in the estate of the bankrupt, but shall include property held by the debtor in trust for any other person. Now, please compare this section with the section of insolvency. During insolvency, if there is any disposition of property, so what will happen? Suppose a petition has been filed for insolvency. Here we are talking of bankruptcy. But suppose a petition has been filed for insolvency and it has not yet been admitted and the debtor disposes of the property. Then what will happen in that situation? The answer is given in section 101. Section 101 2C, if we see, it says that during the moratorium period, the debtor shall not transfer, alienate, encumber, or dispose of any of his assets or his legal rights or beneficial interest therein. But this restriction is after the insolvency commencement date. Now the point is that if the insolvent, if the personal guarantor for whom rules and regulations have been notified, if he transfers after the date of filing and before the insolvency commencement date, then what will happen? I think we can get the answer in section 100. Section 100 says, section 100 subsection 4. If the application referred to in section 94 or 95, as the case may be, is rejected by the adjudicating authority on the basis of report submitted by the RP that the application was made with the intention to defraud his creditors or the resolution professional, the order under subsection 1 shall record that the creditor is entitled to file for a bankruptcy order. So section 100 subsection 4 takes care of this. Suppose a person files the application and in the meantime disposes of the property. So RP will give his report that okay, he has already disposed of his property during this period. And then the adjudicating authority may entitle the creditor directly to proceed for bankruptcy. This is one section. Section 100 subsection 4. Okay. Now, after acquired property, what is the difference after acquired property? After acquired property, there is a definition where it is given after acquired property. Yes, it is given in the explanation to section 159. What it says, the meaning of after acquired property is any property which has been acquired or has devolved upon a bankrupt after the bankruptcy commencement date. Okay? Like in our case study, we saw the example that his father died and certain property devolved upon him. So this is talking of that scenario. After acquired property, it may be acquired, it may devolve. So in both cases, it will be covered under after acquired property. The bankruptcy trustee shall be entitled to claim for the estate of the bankrupt any after acquired property by giving a notice to the bankrupt. And a notice under subsection 1 shall not be served in respect of excluded assets because excluded assets are not to be covered in bankruptcy estate. Okay? Or any property which is acquired by or devolves upon the bankrupt after a discharge order is passed. Because once a discharge order is passed, then the bankrupt is as good as any ordinary person. So, what is to be excluded? Excluded assets and any property which is acquired by or devolves upon the bankrupt after a discharge order is passed. Now the notice. The notice shall be given within 15 days on which the acquisition or devolution of the after acquired property comes to the knowledge of the bankruptcy trustee. Now, what happens if he is not able to give the notice within 15 days, then in that case, he has to take the permission of the adjudicating authority. Okay? For the purpose of subsection 3, anything which comes to the knowledge of the bankruptcy trustee shall be deemed to have come to the knowledge of the successor of the bankruptcy trustee at the same time. And anything which comes to the knowledge of a person before he is appointed as a bankruptcy trustee shall be deemed to have come to his knowledge on the date of his appointment as bankruptcy trustee. Okay? The bankruptcy trustee shall not be entitled by virtue of this section to claim from any person who has acquired any right over after acquired property in good faith for value and without notice of the bankruptcy, So that means this transaction will be considered as
Valid.
valid. Okay? So he cannot claim from any person. But naturally, he will claim the money because suppose the bankrupt has sold some property. So then he might have got some money.
Yes, the seller might have got this.
Right.
He can claim from the seller.
Right. A notice may be served after the expiry of the period under subsection 3 only with the approval of the adjudicating authority. Okay? So within 15 days of coming into his knowledge, he will issue the notice for claiming, and in case 15 days have expired, then he will issue it with the approval of adjudicating. Okay. Explanation we have already seen. Section 160, onerous property of the bankrupt. So what is this onerous property? This concept we have already seen in insolvency and bankruptcy also, insolvency and liquidation also. Onerous property. Onerous property explanation. For the purpose of this section, the term onerous property means any unprofitable contract and any other property comprised in the estate of the bankrupt which is unsaleable or not readily saleable or is such that it may give rise to a claim. So what he will do in this case, the bankruptcy trustee may, by giving notice to the bankrupt or any person interested in the onerous property, disclaim any onerous property which forms a part of the estate of the bankrupt. Okay? The bankruptcy trustee may give the notice under subsection 1, notwithstanding that he has taken possession of the owner's property, endeavored to sell it, or has exercised right of ownership in relation to it. In the material which I have already given it to you, I have framed illustrations on each of these sections. So if you go through those illustrations, you can easily understand these sections. A notice of disclaimer under subsection 1 shall determine as from the rate of such notice, the rights, interests, and liabilities of the bankrupt in respect of the owner's property disclaimed, discharge the bankruptcy trustee from all personal liability in respect of the owner's property as from the rate of appointment of the bankruptcy trustee. Okay. A notice of disclaimer under subsection 1 shall not be given in respect of the property which has been claimed for the estate of the bankrupt under section 155 without the permission of the committee of creditors. Okay. A notice of disclaimer shall not affect the rights or liabilities of any other person and any person who sustains a loss or damage in consequence of the operation of a disclaimer under the section shall be deemed to be a creditor of the bankrupt to the extent of the loss or damage. Now we can take the example of onerous property. Suppose a bankrupt is running a cinema hall and that cinema hall is a single screen cinema hall located in a village. He tried to sell it, but there are no takers. There are no buyers. Or say a leased property. The cinema hall has been taken, lease rights, exhibition rights of that cinema hall have been taken, which are appearing in the books. But there are no takers because single screen time has gone now. Even if he gave the advertisement in paper, but no takers were there. So he can disclaim. But suppose there is a canteen contractor in that cinema hall. Okay? And that canteen contractor has also been given lease of say 5 years. And he has say affixed certain fixtures and fittings for that canteen purpose. He has mobilized some equipment for catering equipment. And he may suffer a loss in case this property is disclaimed. So he will be considered to be a creditor to that extent. If you go through the illustrations, you will clearly understand what is the meaning. So 160. 161. Notice to disclaim owner's property. Because this property is lying in the books. Like I gave you the example of exhibition rights in a cinema hall. है ना? But now, since it is located in a rural area, it's a single screen cinema, so there are no takers as of now. So notice to disclaim the owner's property. 161. Because you have to remove it from the books. So what it says? It says no notice of disclaimer under section 160 shall be necessary if a person interested in the owner's property has applied in writing. The word is applied in writing. If he inquires on phone, that may not be sufficient to the bankruptcy trustee or his predecessor, requiring him to decide whether the owner's property should be disclaimed or not. Okay. Suppose there is an agricultural land which is owned by that bankrupt, and he has given it on sublease to a agricultural farmer, and that farmer inquires in writing. So that is the scenario which is being described here. And a decision under clause A has not been taken by the bankruptcy trustee within 7 days of receipt of the notice. Any owner's property which cannot be disclaimed under subsection 1 shall be deemed to be part of the estate of the bankrupt. For the purpose of this section, an owner's property is said to be disclaimed where notice in relation to that property has been given by the bankruptcy trustee under section 160. Now 162, disclaimer of leaseholds. So similarly, there may be some freehold property, there may be some leasehold property also. So suppose lease is there, so in that case you can disclaim it if it is unprofitable, if it is not saleable. The bankruptcy trustee shall not be entitled to disclaim any leasehold interest unless a notice of disclaimer has been served on every interested person. Because in case of lease, there may be a sub-lessee also. Suppose it's a mining lease. Suppose it is lease to run the cinema hall. So in that case, there may be some other persons also who may be interested. So you have to give the notice of disclaimer to every interested person. And no application objecting to the disclaimer by the interested person has been filed with respect to the leasehold interest within 14 days of the date on which the notice was served. And where the application objecting to the disclaimer has been filed by the interested person, the adjudicating authority has directed under section 163 that the disclaimer shall take effect. Where the adjudicating authority gives a direction under clause B of subsection 1, it may also make order with respect to fixtures, improvements by tenant and other matters arising out of the lease as it may think fit. So this is something similar to the illustration which I have given in the case study. Cinema hall being run on lease and there is a canteen contractor. So he has put some fixtures or improvements. Now the adjudicating authority will decide what will happen to those things. Take it. 163. Challenge against disclaimed property. An application challenging the disclaimer may be made by the following persons under this section to the adjudicating authority. All these things will be done with the approval of the adjudicating authority only. Disclaimer will also be disclaimer of property, disclaimer of owner's property, then disclaimer of leaseholds, everything will be done with the approval of the adjudicating authority only. Now suppose the adjudicating authority has done something and now this person wants to challenge. So he will apply to the adjudicating authority. An application challenging the disclaimer may be made by the following persons under this section to the adjudicating authority. Any person who claims an interest in the disclaimed property, or any person who is under any liability in respect of the disclaimed property, or where the disclaimed property is a dwelling house, any person who on the date of application for bankruptcy was in occupation of or entitled to occupy that dwelling. So he may challenge before the adjudicating authority. And the adjudicating authority may on an application under subsection 1 make an order for the vesting of the disclaimed property in or for its delivery to any of the persons mentioned in subsection 1. Okay. The adjudicating authority shall not make an order in favor of a person who has made an application under clause B of subsection 1, except where it appears to the adjudicating authority that it would be just to do so for the purpose of compensating the person. Okay. The effect of an order under this section shall be taken into account while assessing loss or damage sustained by any person in consequence of the disclaimer under subsection 5 of section 160. An order under subsection 2 vesting property in any person need not be completed by any consequence, assignment or transfer. 164. Undervalued transaction. Similar to section 45. The period here is 2 years preceding the filing of application. So what is the reference? There it is 2 years period before the insolvency commencement date. If we read section 45, then what is the period in section 45?
2 years and 1 year.
2 years. No, 2 years before what? Before the insolvency commencement date or date of filing?
Insolvency commencement date.
Yes, insolvency commencement date is given in section 46. But here it is date of filing. So this is the difference. The bankruptcy trustee may apply to the adjudicating authority for an order of this section in respect of an undervalued transaction between a bankrupt and any person. The undervalued transaction should have been entered into during the period of 2 years ending on the filing of the application for bankruptcy. But there the period is 2 years or 1 year preceding the insolvency commencement date. Section 45 and 46. Here it is 2 years before the date of filing of the application for bankruptcy. And cause the bankruptcy process to be triggered. This is also important. A transaction between a bankrupt and his associate entered into during the period of 2 years preceding the date of making of the application for bankruptcy shall be deemed to be an undervalued transaction. So there is a deeming fiction here. If there is any transaction between the bankrupt and his associate, even if it is on market value, there is a deeming fiction that it is an undervalued. Like we saw the case in case study, he has transferred his some property to his associate, and that was done at market value. But there is a deeming fiction that it is an undervalued transaction. Okay. And what is the period? 2 years preceding the date of making of the application for bankruptcy. On the application of the bankruptcy trustee under subsection 1, the adjudicating authority may pass an order declaring an undervalued transaction void, pass an order requiring any property transferred as a part of an undervalued transaction to be vested with the bankruptcy trustee as a part of the estate, and pass any such other orders if it thinks fit. Okay. The order under clause A of subsection 4 shall not be passed if it is proved by the bankrupt that the transaction was undertaken in the ordinary course of business of the bankrupt, provided that the provisions of this section shall not be applicable to undervalued transaction entered into between a bankrupt and his associate. Okay. So this plea of ordinary course of business will also not work in case of a transaction between a bankrupt and his associate. Okay. And what is undervalued? For the purpose of this section, a bankrupt enters into an undervalued transaction with any person if he makes a gift. सारा प्रोविजन सेम है जो वहां पर दिया हुआ है आपका. अगर सेक्शन 45 देखें, 45, 46 वही है. बट वहां पर मैरिज नहीं है. वो मैरिज इसलिए नहीं है कि वहां पर वो कंपनी है ना. सो इफ ही मेक्स ए गिफ्ट, नो कंसिडरेशन हैज बीन रिसीव्ड बाय दैट पर्सन फ्रॉम द बैंकक्रप्ट. ठीक है. It is in consideration of marriage, or it is for a consideration the value of which in money or money's worth is significantly less than the value in money or money's worth of the consideration provided by the bankrupt. ठीक है. देखो पहला तो समझ में आ गया, पहले में कोई दिक्कत नहीं है. He makes a gift to that person. The bankrupt is giving something for free, तो undervalued हो गया. Second, no consideration has been received by that person फ्रॉम द बैंकरप्ट। क्या मतलब इसको, कैन यू एक्सप्लेन दिस थिंग? नो कंसिडरेशन हैज बीन रिसीव्ड बाय दैट पर्सन फ्रॉम द बैंकरप्ट, तो भी अंडर वैल्यूड ट्रांजेक्शन। हाँ जी, एनीवन? अजय जी, इसका क्या मतलब हो सकता है? नो कंसिडरेशन हैज बीन रिसीव्ड बाय दैट पर्सन फ्रॉम द बैंकरप्ट। सो देयर आर टू पर्सन्स, वन इज बैंकरप्ट एंड द अदर इज द अदर पर्सन, से शॉपकीपर। नाउ द बैंकरप्ट गोज टू ए शॉप, ठीक है? नाउ ही गोज टू दैट शॉप and he takes a pair of shoes from him and he doesn't give any money. No consideration has been received. So in that case also it will be deemed to be an undervalued transaction. ठीक है? No consideration has been received by that person from the bankrupt. There is a car dealer. The bankrupt goes to that car dealer and the bankrupt gets a car without paying anything. Then that thing also is undervalued transaction. If it is in consideration of marriage, if the bankrupt gives something in consideration of marriage, that is also a undervalued transaction. It is for a consideration, the value of which is money or money's worth is significantly less the value in money or money worth of the consideration provided by the bankrupt. ठीक है? मतलब ये है कि bankrupt has a property say of 10 crores and he gets 2 crores for that property. So this is an undervalued transaction. Preference transactions. Similar to section 43, the bankruptcy trustee may apply to the adjudicating authority for an order on this, under this section if a bankrupt has given a preference to any person. ठीक है? और preference क्या है? It is 2 years ending on the date of application. ये देखिए यहां पर थोड़ा सा फर्क है। वहां पर क्या है? वहां आपकी इंसॉल्वेंसी कमेंसमेंट डेट से शुरू करता है, ये कर रहा है ऑन द डेट ऑफ फाइलिंग ऑफ द एप्लीकेशन फॉर बैंक्रप्सी। ठीक है? एंड दिस ट्रांजेक्शन इज एंटर्ड इनटू विद द एसोसिएट। ये भी इंपॉर्टेंट है ना? एनी ट्रांजेक्शन गिविंग प्रेफरेंस not covered under subsection 2 should have been entered into by the bankrupt during the period of 6 months ending on the date of application for bankruptcy. So if the transaction is with the associate, the period is 2 years. If the transaction is with somebody other than the associate, then the period is 6 months. वहां पर 2 year और 1 year है ना? वहां पर इंसॉल्वेंसी कमेंसमेंट डेट है, यहां पर है डेट ऑफ फाइलिंग ऑफ द एप्लीकेशन फॉर बैंक्रप्सी। ठीक है? Now what is preference? The transaction giving preference under subsection 2 or subsection 3 should have caused the bankruptcy process to be triggered. ठीक है? यह ट्रिगर होना चाहिए इसकी वजह से। अंडर वैल्यू ट्रांजेक्शन में भी सेम कंडीशन है, यहां पर भी। On the application of the bankruptcy trustee under subsection 1, the adjudicating authority may pass an order declaring transaction void, pass an order requiring the property to be vested back, pass any other order as it deems fit. ठीक है? The adjudicating authority shall not pass an order under subsection 5 unless the bankrupt was influenced in his decision of giving preference to a person by a desire to produce in relation to that person as effect under clause B of subsection 8. ठीक है? तो वो क्या इफेक्ट है वो भी देख लेते हैं। For the purpose of this section, a bankrupt shall be deemed to have entered into a transaction giving preference to any person if वही सारी कंडीशंस जो आपकी 43 में है। The person is the creditor, surety or guarantor and the bankrupt does anything or suffers anything to be done which is the effect of putting that person in a position which in the event of the debtor becoming bankrupt will be better than the position he would have been if that thing had not been done. वही 43 वाला ही चीज है। 43 में क्या है? वाटरफॉल मैकेनिज्म को चेंज करता है। यहां पर ये वही बता दिया कि भाई ही विल बी इन ए बेटर पोजिशन। और 7 क्या है? For the purpose of subsection 6, if the person is an associate of the bankrupt, other than by reason of being his employee, at the time when the preference was given, it shall be presumed that the bankrupt was influenced in his decision under that subsection. ठीक है, तो अगर ट्रांजेक्शन रिलेटेड पार्टी के साथ है तो देयर इज ए प्रिजम्पशन यहां पर 166 166 बोलता है इफेक्ट ऑफ द ऑर्डर subject to the provisions of subsection 2, an order passed by the adjudicating authority under section 164 or 165 shall not give rise to a right against a person interested in the property which was acquired in an undervalued transaction or transaction giving preference, whether or not he is the person with whom the bankrupt entered into such transaction, and require any person to pay a sum to the bankruptcy trustee in respect of the benefit received from the undervalued transaction or transaction giving preference, whether or not he is the person with whom the bankrupt entered into such transaction. The provisions of subsection 1 shall apply only if the interest was acquired or the benefit was received in good faith, for value and without notice. ठीक है, without notice that the bankrupt has filed an application for bankruptcy or a bankruptcy order has been passed, and by any person who at the time of acquiring the interest or receiving the benefit was not an associate of the bankrupt. ठीक है, any sum required to be paid to the bankruptcy trustee shall be included in the estate of the bankrupt. 167 extortionate transactions, वहां पर कितना कौन सा कॉरेस्पॉन्डिंग सेक्शन है? सेक्शन 50. सब्जेक्ट टू सब सेक्शन, पहले इसका मतलब देख लेते हैं. एक्सटॉर्शनेट क्रेडिट ट्रांजैक्शन का एक्सप्लेनेशन में दिया होगा.
No explanations.
है
No explanations.
कोई बात नहीं, वो एक्सटॉर्शनेट क्रेडिट ट्रांजैक्शन वो वहां पर जो मीनिंग दिया गया सेम ही है ये.
50 years.
हाँ, सेक्शन 50 में जो है वो सेम ही है. Subject to subsection 6, on an application by the bankruptcy trustee, the adjudicating authority may make an order under this section in respect of extortionate credit transactions. नहीं दे दिया ना इसमें, 167 में दे दिया, सबसेक्शन 5 में दे दिया ना इसका.
हाँ सर.
सबसेक्शन 5 में मीनिंग दे दिया इसका. For the purpose of this section, an extortionate credit transaction, ये दे दिया ना, is a transaction for or involving the provision of credit to the bankrupt by any person on terms requiring the bankrupt to make exorbitant payments or which is unconscionable under the principles of law relating to contracts. तो ये मीनिंग दे दिया इन्होंने. ये 5 और 6 है. तो पीरियड हियर इज 2 years एंडिंग ऑन द बैंक्रप्सी कमेंसमेंट डेट. ये इंपॉर्टेंट है. देखिए दोनों में वहां क्या था? फाइलिंग ऑफ एप्लीकेशन था इन केस ऑफ प्रेफरेंस ट्रांजैक्शन एंड अंडर वैल्यू ट्रांजैक्शन. यहां पर क्या है? एक्सटॉर्शनेट में बैंक्रप्सी कमेंसमेंट डेट से 2 years बिफोर दैट. ठीक है, ड्यूरिंग द पीरियड ऑफ 2 years एंडिंग ऑन द बैंक्रप्सी कमेंसमेंट डेट. और ऑर्डर में क्या करेगा? तो दे में सेट असाइड और दे में वेरी द टर्म्स ऑफ द कॉन्ट्रैक्ट. ठीक है, obligations under contracts 168. Now what is the meaning? Suppose this bankrupt is a partner or is executing a project in joint venture with some other person, then what will be the liability of the other person? So this is explained in section 168. Obligations under contracts. This section shall apply where a contract has been entered into by the bankrupt with a person before the bankruptcy commencement date. Any party to a contract other than the bankrupt under subsection 1 may apply to the adjudicating authority for an order discharging the obligations of the applicant on the bankrupt under the contract and payment of damages by the party or the bankrupt for non-performance of the contract or otherwise. Any damages payable by the bankrupt by virtue of an order shall be provable as bankruptcy debt. Okay? Suppose he is under some obligation and suppose he wants to come out of that contract and some damages are payable, so they shall be treated as bankruptcy debt. Where a bankrupt is a party to the contract under this section jointly with another person, like he is executing some contract jointly, then that person may sue or be sued in respect of the contract without joinder of the bankrupt. So bankrupt may not join with him, so he may be sued singly. This is the meaning. 169. Continuance of proceedings on death of the bankrupt. If a bankrupt dies, the bankruptcy proceedings shall continue as if he were alive. 170. Administration of estate of the deceased bankrupt. All the provisions of chapter 5 shall, so far as the same applicable, apply to the administration of the estate of a deceased bankrupt. And while administering, the regard shall be had to the claims regarding proper funeral and testamentary expenses. This we have seen yesterday also. So they will be in pari passu with the secured creditors, rights of secured creditors. Okay. The claims under subsection 2 shall rank equally to the secured creditors in the priority provided under section 178. Okay. If on the administration of the estate of a deceased bankrupt, any surplus remains in the hands of the bankruptcy trustee after payment in full of all the debts due from the deceased bankrupt, together with the cost of administration and interest, such surplus shall be paid to the legal representatives. Okay. Now, proof of debt. The bankruptcy trustee shall give notice to each of the creditors to submit proof of debt within 14 days of preparing the list of creditors under section 132. Okay. But before we go to this, let us see the illustrations on this. Sections, अभी अभी जो हमने सेक्शन देखे उसकी illustrations एक बार हम देख लेते हैं, वो ज्यादा जरूरी है. अभी we have got still half an hour, तो उस half an hour में आप अपना illustrations को देख लेते हैं, वो ज्यादा जरूरी. एक मिनट. ये सो दीज आर द इलस्ट्रेशंस बेस्ड ऑन सेक्शन 158 टू 163. अभी अभी हमने जो सेक्शन पढ़े ये उनकी इलस्ट्रेशंस है. तो एक बार पढ़िए जरा प्रदीप जी, प्लीज रीड दिस इलस्ट्रेशन. और एक किसने पढ़ी है, ऑलरेडी पढ़ी है किसी ने? दिस मटेरियल आई हैव ऑलरेडी शेयर्ड. तो आप में से किसी ने पढ़ी है इलस्ट्रेशन या नहीं पढ़ी किसी ने?
Few have read, sir. Few.
हाँ जी.
2-3 case studies, yeah, I have gone through, sir.
Okay, okay. So please read this. Section 158. So section by section, I have explained by way of examples here. 158. Yes, please. Please read this.
That no screen is visible, sir.
No screen is visible. एक मिनट. है ना? I hope now it is visible.
Yes, sir.
Okay. Please.
So Mohanlal stood a guarantor for loan taken by XYZ Limited from PNB. On default by XYZ Limited, insolvency proceedings were initiated by PNB against Mohanlal under Section 95. The repayment plan proposed by Mohanlal could not be completed, and bankruptcy proceedings were initiated against Mohanlal by PNB. PNB had applied under Section 123 on 1st December 2021, and the application was admitted by, sir, is it DRT or NCLT?
It is NCLT only. Section 60 subsection 1.
Okay.
if we read section 60 subsection 1 with section 179, then proceedings for personal guarantors to corporate debtor will be dealt with by NCLT.
Okay. By NCLT, wide its order under section 126 on 15th January 2022. Discharge order under section 138 was issued on 20th February 2023. Mohanlal has following properties as on 1st December 2021. Residential unit in Bangalore worth 20 lakhs, leasehold rights in canteen in a cinema hall, commercial plot worth 60 lakhs and gold jewelry worth 5 lakh devolved upon him on death of his father. Mohanlal's father died on 25th February 2023. Mohanlal is a trustee in a trust and is holding property worth 15 lakhs on behalf of the trust, agriculture land in a village.
So these are the facts of the case. Yes.
Based on the above facts, please answer the following questions. He entered into an arrangement on 5th December 2021 to sell the Bangalore residential unit to Chandrasekharan. Shekaran is not aware about the bankruptcy proceedings initiated against Mohanlal and has acquired the residential unit in good faith for value and with notice of the bankruptcy proceedings. In view of the above, which of the following option is correct? Section 158. That's this.
Yes. Actually, in section 158, what are the things we have to see? I have reproduced section 158 here also for your reference. So what we have to see? First of all, we have to see the date of filing of the application. Second
1st
is
December.
bankruptcy commencement date. What is the date of filing of the application?
1st December 2021, sir.
Okay. And what is the date of
15th January 2022.
15th January 2022?
22. So
And what is
he's
the date of transfer of this
5th,
property?
5th December, sir.
5th December. So it falls between these two dates.
Yeah, it's void.
ठीक है ना? So it is void. Yes.
So see, sir, transaction of transfer is
Yes.
void.
Right. So what I have done is I have reproduced this section here also for the sake of your ease. है ना? कि भाई आपको अलग से नहीं पढ़ना पड़ेगा. Now next point.
Continuing with the above
Now
illustration.
this question is based on section 159.
Continuing with the above illustration, what are the rights of bankruptcy trustee Amit Talwar in case the property devolved upon Mohanlal has been disposed of by Mohanlal to Rooplal? Rooplal has acquired this property in good faith for value and without notice of the bankruptcy proceedings. In view of the above provisions, which of the following option is correct?
So here we have to see that certain property has devolved upon Mohanlal. Now let us see the period when this property has devolved upon him. This property has devolved upon him on 25 February 2023. And what is the date of discharge order?
20th February 2023. So after
Yes.
the discharge orders.
Yes. So if anything devolves upon a person after the discharge order, that belongs to him. ठीक है ना?
Yes, sir. So he cannot serve any notice. The bankruptcy trustee.
Right. So this is 159. 159 says that notice cannot be served in respect of excluded assets or any property which is acquired by or devolves upon the bankrupt after a discharge order is passed under section 138.
Right.
So in this case, what will be the answer? Whether the bankruptcy trustee can give notice?
No, sir.
So the option is D, because both the properties have devolved upon Mohanlal after the date of discharge order under section 138. Though these transactions are not covered under section 159. ठीक है? चलिए next 160.
Continuing with the above illustration, what are the rights of bankruptcy trustee regarding the agricultural land situated in a village? The bankruptcy trustee Amit Talwar had issued advertisement in local newspaper about the proposal to sell agricultural land, but nobody came forward. The land is situated near a Nalla, Sukhbir
So you
Singh.
can say a drain, है ना?
Drain, yeah,
नाला है ना? नाला मतलब drain.
Sorry, Nala.
इसको drain कर देते हैं हम, छोड़ो.
Okay.
Drain. because everybody may not understand what is this nala. हाँ जी, चलिए.
Sukhbir Singh had been given the rights to grow crops on the land for a period of 5 years. Sukhbir Singh came to know that the bankruptcy trustee is interested in a disclaimer of onerous property and has written to Amit Talwar that he has spent a sum of 25,000 toward mobilization of resources to sow the agriculture land.
So now this bankrupt is having some agricultural land and he has given it on lease to Sukhbir Singh. So Sukhbir Singh is a person who is interested in that property, in that owner's property, and he has spent some money also. So what section 160 says? First of all, let us see what section 160 says. This is section 160.
The bankruptcy trustee may, by giving a notice to the bankrupt or any other person interested in the onerous property, disclaim any onerous property which forms a part of the estate of the
Right.
bankrupt.
So who is the interested person here? Interested person is Sukhbir Singh.
Sukhbir.
Yes.
The bankruptcy trustee may give the notice under subsection 1, notwithstanding that he has taken possession of the onerous property, endeavored to sell it, or has exercised rights of ownership in relation to it.
So this point number 2 is also explained here. He has issued advertisement in paper, है ना? But nobody came forward. So he has endeavored to sell it, है ना? And or he has exercised rights of ownership. Yes.
A notice of the disclaimer under subsection 1 shall determine as from the date of such notice the rights, interest, liabilities of the bankrupt in respect of the onerous property disclaimed. Discharge the bankruptcy trust from all the personal liability in respect of onerous property as from the date of appointment of the bankruptcy trustee. A notice of the disclaimer under subsection 1 shall not be given in respect of the property which has been claimed for the estate of bankrupt under section 155 without the permission of the committee of creditors. A notice
So
of
this is the owner's property. So now what is the answer? First, the bankruptcy trustee can disclaim the agricultural land without giving a notice to anyone.
No, sir. He
No.
has to give a notice.
Right. Because Sukhbir Singh is the person interested in property. Second, the bankruptcy trustee can disclaim the agricultural land after giving a notice to Mohan Lal and Sukhbir Singh. Now Sukhbir Singh is this person. Who is Mohan Lal?
He's the debtor. He's the debtor, sir.
Right. So Mohan Lal is the debtor. And point number C. So whether he has to give a notice to the debtor also, he has to give a notice to the bankrupt also. This is the question. Suppose a bankruptcy trustee wants to disclaim the owner's property. So whether he has to give his notice to the bankrupt also, or he has to give notice only to the person who is interested in the property.
Sir, it is written or bankrupt or any person.
So or should be read as and.
And
है ना? So he will give notice to both.
yes.
है ना? Yes. So third option is correct, that the bankruptcy trustee can disclaim the agricultural land after giving a notice to Mohan Lal, who is the owner, who is the bankrupt, and Sukhbir Singh. Sukhbir Singh is the person interested because he was given that land to sow, for sowing crops, for growing crops.
Yes.
However,
So
Sukhbir Singh can claim the amount of rupees 25,000 and shall be deemed to be a creditor of Mohan Lal, the bankrupt, to that extent, because he has spent this money towards mobilization of resources to sow the agricultural land. है ना? ये लिखा ना, he shall be deemed to be a creditor of the bankrupt to the extent of the loss or damage. Point number 5, section 160 subsection 5. ठीक है, क्लियर है?
yes.
चलिए नेक्स्ट.
Continuing with the above illustration, Rajbir Singh, on coming to know of the advertisement for sale of the agricultural land, has visited the office of Amit Talwar and inquired from him on phone whether bankruptcy trustee wanted to disclaim the agricultural land. However, Amit Talwar informed him that no decision has yet been taken and he would let him know in case of any further development in the matter. In view of the above, can
So
bankruptcy
now another person has come, Rajbir Singh. But Rajbir Singh, he has not given anything in writing. He has inquired on phone. What is the provision of 161? That he has to inquire in writing.
in writing? Yeah.
161, if we see what it says a person interested in the property has applied in writing, है ना, requiring him to decide. So he can go ahead with the disclaimer. Now 162, yes.
Continuing with the above illustration, Mohanlal has got leasehold rights in a canteen in a cinema hall. He has, however, sublet the canteen to Narayan Murthy for a period of 5 years. Narayan Murthy has mobilized the necessary fixtures and appliances for the canteen and shall suffer damages of 2 lakhs in case the canteen contract is cancelled. Amit Talwar had given a notice of disclaimer to Narayan Murthy, but Narayan Murthy was in his ancestral village when the notice was received and could not raise any objection. On his return from the village, an application objecting to the disclaimer was filed by the advocate of Narayan Murthy but was not admitted by the adjudicating authority. In view of the above, can the lease rates of cinema hall be disclaimed?
Actually, the application has been filed with the adjudicating authority. So adjudicating authority will decide and Narayan Murthy can become creditor to the extent of rupees 2 lakhs. Yes, next question.
The adjudicating authority in its order directed Narayan Murthy to remove the fixtures installed by him without any directions as to costs.
So in this case, Narayan Murthy can claim rupees 2 lakhs, but not the cost of removal of the fixtures. Okay. Next, 162. This is 162. 163. Yes.
Continuing with the above illustration, an application challenging the disclaimer may be made by the following persons under section 163 to the adjudicating authority by.
So who was Sukhbir Singh? Sukhbir Singh was the person who was growing crops. है ना?
Yes.
Narayan Murthy is the lessee in the canteen contract.
Sublet. हाँ, रूपलाल.
हाँ. रूपलाल कौन है?
He has inquiry. He made an inquiry in the agriculture land. I think.
नहीं, वो तो मोहनलाल था.
No, sir. Mohanlal is the debtor. Ruplal is the person who made inquiry into the.
नहीं, वो तो रूपलाल was the person to whom the property was sold. So
Okay.
Ruplal has got nothing to do with this. है ना? So answer will be A and B.
B.
Sukhbir Singh and Narayan Murthy. Ruplal and Chandrasekharan, they have got nothing to do with this. Ruplal कौन था? Ruplal was the person to whom the property was disposed of by मोहनलाल. है ना? उसका कोई मतलब नहीं इस बात से. और चंद्रशेखरन कौन है?
Oh, Bangalore flat, I think, sir.
हाँ, तो उसका भी कोई मतलब नहीं है इससे. है ना? हाँ. ठीक है जी. तो दिस वे आई हैव ट्राइड टू एक्सप्लेन ऑल दीज इलस्ट्रेशंस. अभी चलते हैं इस पे थोड़ा सा कुछ और कर लेते हैं. वही हमने बेयर कोड पर चलते हैं हम लोग. अब देखो कुछ तो समझ में आया होगा ना इस तरह से, नहीं? क्यों प्रदीप जी?
Yes, sir. Yes, sir.
है ना? और अभी आप वंस यू गो थ्रू दिस इलस्ट्रेशन ना 2-3 टाइम्स, तो आप यू विल अंडरस्टैंड इट कंप्लीटली. अभी मैंने क्या किया इसमें ना, आई प्रोवाइडेड द लिंकेजेस ऑल्सो. यहाँ पर जैसे जो भी बैंक्रप्सी वाला था ना, जहाँ पर जो रूल है, जो सेक्शन है, उस पर यू विल क्लिक इट और वहां पर आपको वो रूल या सेक्शन भी मिल जाएगा. अभी एक बार देख लेते हैं हम लोग कहां पर थे। 171 है ना, 171 पर थे। अप टू सेक्शन 170 वी हैव कवर्ड 171। अभी देयर इज स्टिल टाइम, अभी तो 15-20 मिनट है हमारे पास, ठीक है। 171 प्रूफ ऑफ डेट। द बैंक्रप्सी ट्रस्टी, देखो ऐसा है कि यू विल हैव टू हेल्प मी। आप क्या करो, आप दिन में पढ़ाई करो या सुबह पढ़ाई करो। और ऐसा मत सोचो कि सिर्फ क्लास अटेंड करने से समझ में नहीं आएगा। क्लास के अलावा आपको भी पूरा अपना पढ़ाई करनी है। जो मैं आपको मटेरियल देता हूं, यू हैव टू रीड इट, तभी समझ में आएगा। 171 प्रूफ ऑफ डेट। The bankruptcy trustee shall give notice to each of the creditors to submit proof of debt within 14 days of preparing the list of creditors under section 132. ठीक है। The proof of debt shall require the creditor to give full particulars of debt, including the date on which the debt was contracted and the value at which that person assesses it. ठीक है, दोनों चीजें हैं इसमें। तो दैट मीन्स वो क्या करेगा, अपना इंटरेस्ट भी लगा लेगा उस पर। वैल्यू एट विच दैट, देखो सपोज डेट वाज गिवन 5 years ago, तो आज की डेट में वो उतना वैल्यू तो नहीं रहेगा ना, इट विल बी इंक्रीज्ड, है ना, क्योंकि इंटरेस्ट कंपोनेंट विल आल्सो बी एडेड। तो उसको देना है द वैल्यू एट विच दैट पर्सन असेसेस इट, बिकॉज देयर मे नॉट बी एनी लोन एग्रीमेंट। Require the creditor to give full particulars of the security, including the date on which the security was given and the value at which that person assesses it. इसी तरह से जो सिक्योरिटी है उसका भी वैल्यू बताइए, आज की डेट में कितना वैल्यू है। ठीक है, सपोज ए हाउस हैज बीन मॉर्टगेज्ड, तो वो दिया था 5 साल पहले, अब आज की डेट में उसकी क्या वैल्यू वो भी बताइए। ठीक है, बी इन सच फॉर्म एंड मैनर एज में बी प्रेस्क्राइब्ड, सेक्शन 171 प्रूफ ऑफ डेट। चलिए 172। अच्छा, इन केस the creditor is a decree holder against the bankrupt, a copy of the decree shall be valid proof of debt. Where a debt bears interest, the interest shall be provable as part of the debt except insofar as it is owed in respect of any period after the bankruptcy commencement date. Similar is the provision in liquidation. Liquidation में भी you cannot charge any interest beyond the liquidation commencement date. तो यहां पर भी क्या कह रहा है कि इंटरेस्ट आपको प्रूव कितना करना है, it shall be provable as part of the debt except insofar as it is owed in respect of any period after the bankruptcy commencement date. So you have to claim the interest up to bankruptcy commencement date only. ठीक है, the bankruptcy trustee shall estimate the value of any bankruptcy debt which does not have a specific value. The value assigned by the bankruptcy trustee under subsection 5 shall be the amount provable by the concerned creditor. A creditor may prove for a debt where payment would have become due at a date later than the bankruptcy commencement date, as if it were owed presently, and may receive dividends in a manner as may be prescribed. Suppose the debt is payable at a future time. ठीक है, you have taken a loan for 5 years, but in the second year itself bankruptcy has started, so you have to calculate the present value as if it were owed presently. ठीक है, where the bankruptcy trustee serves a notice under subsection 1 and the person on whom the notice is served does not file a proof of security within 30 days after the date of service of the notice, the bankruptcy trustee may, with the leave of the adjudicating authority, sell or dispose of any property that was subject to security free of that security. ठीक है, provision is something similar to liquidation. In liquidation also, you have to give it in the form itself, whether you want to realize or you want to relinquish the security. Point number 8A, in both the forms to be filed by the financial creditor or operational creditor. Similarly, here also, he has to prove it within 30 days. Otherwise, the bankruptcy trustee may sell it with the approval of the adjudicating authority. ठीक है, 172 proof of debt by secured creditors. Where a secured creditor realizes his security, he may produce proof of the balance due to him. ठीक है, where a secured creditor surrenders his security for the general benefit, he may produce proof of his whole claim. ठीक है, 173 mutual credit set off allowed. 174 distribution of interim dividend. So this is something similar to distribution of estate. Whenever the bankruptcy trustee has sufficient funds in his hands, he may declare and distribute interim dividend among the creditors in respect of the bankruptcy debt which they have respectively proved. Where the bankruptcy trustee has declared any interim dividend, he shall give notice of each dividend and the manner in which it is proposed to be distributed. ठीक है. In the calculation and distribution of the interim dividend, the bankruptcy trustee shall make provision for any bankruptcy debts which appear to him to be due to persons who, by reason of the distance of their place of residence, may not have had sufficient time to tender and establish their debts. ठीक है. Suppose a person could not file proof of debt, say due to employment, he is presently employed in Dubai, है ना, तो he may not be able to prove his debt. तो उस केस में the bankruptcy trustee will make provision. Any bankruptcy debt which are subject of claims which have not yet been determined, disputed proofs and claims, and expenses necessary for the administration of the estate of the bankrupt. So he will make provision and then he will distribute the interim dividend. Now, distribution of property. 175. The bankruptcy trustee may, with the approval of the committee of creditors, divide in its existing form among the creditors according to its estimated value any property in its existing form. Okay. So this he has to do with the approval of the committee of creditors. Okay. Which from its peculiar nature or other special circumstances cannot be readily or advantageously sold. So take the case of laptops.
Yeah.
Suppose old laptops are there. They are no more saleable, but they are with the employees and employees have got dues also. So he may give them.
Distribute.
But he has to take the approval of the committee of creditors.
Right.
But in case of liquidation, he has to take the approval of the adjudicating authority. वहां पर क्या है, वहां आपको adjudicating authority का approval लेना है. Can you tell me the section, प्रदीप जी? Can you tell me the section in liquidation? लिक्विडेशन में एक सेक्शन है जिसमें क्या बोलता है कि with the approval of the adjudicating authority. I think you will get it in regulations. If you go to liquidation process regulations, you may get it. Regulation number 38. Regulation 38 of liquidation process regulations. The liquidator may, with the permission of the adjudicating authority, distribute among the stakeholders an asset that could not be sold, assigned or transferred due to its peculiar nature or other special circumstances. ठीक है, तो सेम ही लग रहा है यहाँ पर भी, है ना?
Yes, sir.
वहां पर क्या है, वहां आपको एडजुडिकेटिंग अथॉरिटी का अप्रूवल लेना है. यहाँ पर किसका अप्रूवल लेना है? कमेटी ऑफ क्रेडिटर्स का. ठीक है. An appeal under subsection 1 shall be sought by the bankruptcy trustee for an approval under subsection 1 shall be sought by the bankruptcy trustee for each transaction, and a person dealing with the bankruptcy trustee in good faith and for value shall not be required to inquire whether approval has been given or not. Where the bankruptcy trustee has done anything without the approval of the COC, the committee may, for the purpose of enabling him to meet his expenses out of the estate of the bankrupt, ratify the act of the bankruptcy trustee. ठीक है. The committee of creditors shall not ratify unless it is satisfied that it was done in case of urgency. ठीक है. Now final dividend 176. Where the bankruptcy trustee has realized the entire estate of the bankrupt or so much of it as could be realized in the opinion of the bankruptcy trustee, he shall give notice of his intention to declare a final dividend or that no dividend or further dividend shall be declared. The notice under subsection 1 shall contain such particulars as may be prescribed and shall require all claims against the estate of the bankrupt to be established by a final date specified in the notice. So section 176. So 176 में क्या है कि whether there is any form of notice, ये आपको कहाँ दिया गया है? ये दे दिया आपको रूल नंबर 13 में. तो एक बार रूल नंबर 13 और देख लेते हैं कि रूल 13 क्या बोलता है. ये हमारा रूल 13 है, नोटिस ऑफ डिविडेंड. ठीक है, मैंने क्या किया, क्रॉस लिंकिंग कर दिया है. तो आप वहां क्लिक करोगे, रूल निकल जाएगा, नोटिस ऑफ डिविडेंड. The notice of dividend as per clause A of subsection 1 of section 176 shall contain the following particulars: date on which the dividend is proposed to be distributed, list of creditors, amount of dividend, request, last date, statement confirming that no further dividend shall be declared. ठीक है, तो ये है हमारा नोटिस ऑफ डिविडेंड. अब देखते हैं वो लास्ट व्यूट से आता है कि नहीं आता. दोबारा वहीं चलते हैं क्या. 176 पर थे ना हम लोग.
Yes.
यहाँ आ गए हम लोग. ठीक है, चलिए. तो फाइनल डिविडेंड रूल नंबर 13 भी हमने देख लिया. अब ये बताइए कि इसमें क्या पेपर में ऐड देनी, क्या करना है.
ये कहीं लिखा तो नहीं है.
हम्म. भाई इसमें देख लेगा, एडजुडिकेटिंग अथॉरिटी से भी पूछ सकता है. अगर जरूरत है तो पेपर में ऐड दे देगा, अगर बहुत सारे क्रेडिटर्स है तो. नथिंग स्पेसिफिकली मेंशन्ड. The adjudicating authority may, on the application of any person interested in the administration of the estate of the bankrupt, postpone the final dividend date. ठीक है. After the final dividend, the bankruptcy trustee shall defray any outstanding expenses of the bankruptcy out of the estate of the bankrupt, and if he intends to declare a final dividend, declare and distribute that dividend among the creditors who approved their debts without regard to the claims of any other persons. If a surplus remains after payment in full with interest to all the creditors and the payment of expenses of bankruptcy, the bankrupt shall be entitled to the surplus. ठीक है. ये where a bankruptcy order has been passed in respect of one partner in a firm, a creditor to whom the bankrupt is indebted jointly with the other partners in the firm, or any of them, shall not receive any dividend out of the separate property of the bankrupt until all the separate creditors have received the full amount of their respective debts. क्या मतलब है इसका. वो कह रहा है कि where a bankruptcy order has been passed in respect of one partner in a firm. ठीक है. A creditor to whom the bankrupt is indebted jointly with other partners in the firm, or any of them, shall not receive any dividend out of the separate property of the bankrupt until all the separate creditors have received the full amount of their respective debts. मतलब partner of a firm may be liable individually, may be liable because of his relationship with the firm. ठीक है. तो separate property of the bankrupt is to be utilized for the separate creditors, ठीक है, फॉर हिज इंडिविजुअल क्रेडिटर्स एंड प्रॉपर्टी ऑफ द फर्म इज टू बी यूटिलाइज्ड फॉर द डेट्स ऑफ द फर्म. दिस इज द मीनिंग बेसिकली 177. Because even if you are a partner, you may be having some individual debts also. है ना? तो this is the meaning. 171, 177 sorry. Claims of creditors. Last section. आज के लिए. A creditor who has not proved his debt before the declaration of any dividend is not entitled to disturb by reason that he has not participated in the distribution of that dividend or any other dividend declared before his debt was proved. But ठीक है भाई, एक आदमी लेट आया, लेट कमर्स के लिए क्या होगा, पिक्चर तो पहले ही चालू हो गई है, वो कह रहा है शुरू से दिखाओ, नहीं शुरू से नहीं दिखाएंगे. बट व्हेन ही हैज प्रूव्ड द डेट ही शैल बी एंटाइटल्ड टू बी पेड एनी डिविडेंड और डिविडेंड्स which he has failed to receive out of any money for the time being available for the payment of any further dividend. Suppose one tranche of dividend was distributed earlier. Now before the second tranche is distributed to others, he will get his part. Any dividend or dividends payable to him shall be paid before that money is applied to the payment of any such further dividend. ठीक है. No action shall lie against the bankruptcy trustee for any dividend, but if the bankruptcy trustee refuses to pay dividend payable under subsection 1, the adjudicating authority may order him to pay the dividend and pay out of his own money interest on the dividend at the cost of the proceedings in which the order to pay has been made. तो 177. 178 हम कल करेंगे, प्रायोरिटी ऑफ पेमेंट ऑफ डेट्स. एंड व्हाट इज द डिफरेंस बिटवीन 178 and 53? द डिफरेंस इज रिगार्डिंग
Unsecured
government dues. Yes,
government dues
yes,
after.
because government dues here are payable first, है ना, before unsecured creditors. चलिए जी, आज की कथा यहीं समाप्त करते हैं. सबको राम राम.